part 2, summary judgment. There's going to be 3. We've done part 1, this is part 2, and then there's going to be part 3. I have a playlist. It's called Summary of Summary Judgment, and you can check out part 1 if you haven't seen it yet. Otherwise, this might not make as much sense. All right, in this video, we are going to talk about questions of fact, because that is what summary judgment is basically all about. I'm going to explain what questions of fact are and how they work and how you can tell a question of fact from a question of law. But what I want to reiterate is that in this continuum, there are no decisions on questions of fact until you get all the way down to trial. The complaint, a motion to dismiss, an answer, a discovery motion, even a motion for judgment on the pleadings, those can be based on allegations, but no facts have been found. Those are legal issues, not fact issues. So in a trial, in a case where one or both of the parties has asked for it to be a jury trial, which both parties have done here, the judge serves as the legal decision maker, but he or she does not serve as the finder of fact. The jury serves as the finder of fact. And the reason for that is that our system is supposed to be based on the idea that we're looking for truth, right? In terms of figuring out what's more credible, what evidence means what actually happened here. That is the truth. And through our system, it is supposed to be we the people who find the truth. So juries are the fact finder in any case where a jury trial has been requested or in any criminal case whatsoever. So judges do not make decisions of fact. They make decisions of law. And every decision that has been made by Judge Lyman thus far in this case has been a question of law. Questions of law is broad, right? It's everything from procedural things to gag orders to discovery requests to even the motions to and ultimately the order dismissing the Wayfarer complaint. That was a legal decision because he was saying the law doesn't allow recovery for things that have been alleged here. He did not make findings of fact about what happened. He said if they are ultimately able to prove these allegations and they become facts, then the law doesn't allow them to recover, so I might as well dismiss them now. Nothing has happened in the Lively Baldoni case at this point in time that has been a decision on a question of fact. Generally speaking, when a question of fact is decided, you have to have the full-blown due process situation. You have to have cross-examination, and you have to be open to being questioned by the other side. You have to have credibility, be able to be questioned. You have to poke and prod at the evidence before you decide that something is actually fact. You have to comply with the evidence code to make sure that the evidence that's being used is reliable. So there can be circumstances in some cases where issues of fact are decided by a judge on a preliminary or an issue in the middle of the case. For example, if somebody files a complaint and then they ask for a preliminary injunction, right? The merits of the case is off here, but we think we're likely to win and we need you to put an injunction in place until we get there. You would have a full evidentiary hearing for that, and the judge would then make actual findings of fact related to whether an injunction was justified. But you would have a hearing, you would have witnesses, you would have cross-exam, you would have the evidence code, you'd have all those protections that go on findings of fact. And in the end, the findings of facts that apply to the case and to the ultimate liability don't get determined until trial. And this is one of those issues where I think it's actually really helpful to lean on the criminal law stuff that most people know, because it's pretty much the same, right? In a criminal case, you have fact questions like, is the defendant the one who stuck the knife in the victim's head? Or was it someone else? That's a question of fact, right? Did Karen Reed hit John O'Keefe with her car? That's a question of fact, right? So it's the same in civil. Fact questions are, what happened? What are the facts? And if there's disputes of fact, you have to resolve that to determine what are the facts. Because when you get to trial, two things happen. One, the facts are found by the jury. And then two, the jury is instructed on the law and they then apply the law to those facts. So you cannot determine liability at trial until you figured out what the liability attaches to. In other words, you can't determine legal responsibility for conduct until you've agreed on what the conduct is. And that hasn't happened yet in this case, and it's not going to happen unless and until they go to trial. So the way this is taught to most people is that like a car accident and it's like, was the light red or was the light green is a fact issue, right? I think that's so boring. So let's do this. It's a dog bite case. I take Frank to the park. He bites somebody. They sue me over it and say it's my responsibility to pay for their medical bills because my dog bit them. So, fact questions that are going to arise in a case like that are, was it in fact Frank that did the biting? There were lots of dogs there. Was it him? Was I watching him? Was I paying as much attention to him as I should? Did I have any knowledge that he had done this before? Were the injuries that the plaintiff says they sustained from Frank's bite actually caused by Frank? Or were some of those pre-existing injuries? That's a fact issue. Were there witnesses in the park? What did those witnesses see? What did they say they encountered or saw when Frank allegedly bit this person? Those are all questions of fact. What happened? What were the facts and circumstances surrounding the incident that's the basis for the lawsuit? And there can be issues of fact that are undisputed. Like, for example, in that case, maybe like, no, I'll agree it's Frank. It was Frank. I was there. It was my dog. He bit you, right? So that question of fact is easily resolved because we all agree, right? It was my dog, right? But then other questions of fact come out. And as discovery is coming to light, the fact issues start to have sort of sub-issues, right? So like, what did the witnesses say that they saw, right? That's a fact issue. That becomes, there are different accounts from different witnesses about whether I was watching him at the time. One witness says I was and one witness says I wasn't. That's a fact issue because we have two different accounts of the same behavior. Let's say I had no idea he had ever bitten anybody before, but they find a text message between me and my friend that says, oh, I wish Frank would stop biting people. But I testify under oath at a deposition that I have no idea he's ever bitten anyone before. That's a fact issue because it's a credibility determination between one type of evidence and another. The amount of the plaintiff's medical bills is a fact issue. Did you really need to have a boob job because Frank bit your leg? Did Frank really cause that? What are the facts as to why one caused the other? That's a fact issue. So fact issues can come in many forms. They can be records versus testimony. They can be witness versus witness. They can be witness credibility, right? If a plaintiff says one thing and everyone's like, I don't think that's true, even though it's sort of a supposition, they just don't think it's credible, that is a fact issue. The credibility of a witness is a fact issue. Differing interpretations of what happened, that is a fact issue. And this is the important part. The default answer in civil litigation is, if there is any issue of fact, it should be resolved by a jury. The default is, if we have disputed facts, issues of facts, we need to let the jury decide them. That is the default. So what I'm going to talk about next is the circumstance under which the court can say, we don't need to let it get to a jury because there isn't actually an issue of fact the way that it appears.